All right, so hello, folks. Thanks for taking the time to join. I appreciate it. And those of you watching, I also appreciate it as well. Welcome to our workshop on May It Please the Court. This is a new workshop that I'm starting in the second 8-week session of the fall 2021 term. Part of it's because a lot of students have an interest in the Supreme Court. Part of it's because the Supreme Court always has activities going on when they have their when they're in session. And part of it's introducing people to a third branch of government that is not very well known or well understood. So with that, a little bit of background on the workshop and our schedule, and then we'll jump into week 2. So this is focused on exploring the interaction between the U.S. Supreme Court and the federal, state, and or local policy and political institutions, actors, and behaviors. Our workshop is held days from 8 to 8:30, and obviously the Zoom room link is here. And our schedule is the following. So obviously every Tuesday. And last week, I gave an overview of the federal judiciary. So you're welcome to watch the recording there. Today, we'll talk about the U.S. Supreme Court. So its membership, docket, cases, amicus curiae briefs, and oral arguments. And then for weeks 3, 4, and 5, we'll focus on one case and we'll do a mind map of it. We'll start to hear the oral argument. We'll continue the oral argument in the following week, and then we'll wrap up the oral argument and then have a discussion on the case. And then weeks 6, 7, and 8 will be a second case. So if you have a particular case that you're interested in, the keys are that it's occurring in this term of the Supreme Court and that it's already been heard, because we need to be able to listen to the oral argument during our workshop. So if you have ideas for cases, I'll pull up the link to show you where that is, and send me a message on Canvas or via email if you want to recommend one. Okay, let's go ahead and jump to week 2, the U.S. Supreme Court. Here's a picture of the 9 justices, and I'll list who they are in a few slides. So let's jump right in. So our learning objectives with this workshop are first to identify the membership of the Supreme Court. Secondly is to define docket, cases, and amicus curiae briefs. Then the third objective is to explain oral arguments and opinions by the court. So the U.S. Supreme Court is entrusted by our Constitution and by the 2 other political government to serve as an arbitrator to decide what is constitutional and what is not constitutional. Now, the power of the Supreme Court didn't just exist at its founding back in 1789 with the Constitution. It took decades, generations for the Supreme Court to build its credibility, to build its legitimacy, to build its standing, not only with the political branches, but with the public at large. And so on their website, which I'll be pulling a lot of this information from, they quote, "equal justice under the law." These are the words written above the main entrance of the Supreme Court building in Washington, D.C. And it just expresses that this is the ultimate responsibility of the Supreme Court. It's the highest tribunal or court in the nation for all cases and controversies arising under the Constitution or the laws of the United States. And it's the final arbitrator of the law. The court is charged with ensuring that the American people the promise of equal justice under the law, and thereby functions as a guardian and interpreter of the Constitution. Now, Supreme Court consists of a Chief Justice and any number of associate justices that is determined by Congress. The number of associate justices has been decided at 8, and that's according to Title 28 of the U.S. Code, Section 1, which is the citation that you see here. And the power to nominate justices is vested in the President of the United States, and appointments are made with the advice and consent of the Senate. And if you want to learn more, you can click on this link to supremecourt.gov. Now, who are the members of the court? And what you'll see here are our 9 justices, and I'm going to use my draw tool here to help point out who's who. So we'll start here in make sure I have my, this is from, let's see, left to right, starting the first row. This is Samuel Alito here. And then this is Justice Clarence Thomas. This is Chief Justice John Roberts. This is Associate Justice Stephen Breyer. This is Associate Justice Sonia Sotomayor. In the back row here, we have Associate Justice Brett Kavanaugh, who's the second to last newest judge. Here is Elena Kagan. Here's Neil Gorsuch. And then the newest Associate Justice is here, Amy Coney Barrett. So these are the folks, the 9 that decide to which cases to hear. They have oral arguments presented before them. They will meet in private chambers to discuss those cases and to decide who's going to write the opinion, both the majority and the dissenting opinions. And they are collectively the group of people who will decide what is constitutional and what is not constitutional. And it's not just the esoteric idea of saying this is constitutional or not. It's really the idea of who has rights and privileges, who has freedoms and liberties, who has discretion to operate within our political system, within our constitution, laws, and norms that we have in society. So this group as a whole, there is a lot of power here. This group really makes a difference in, I want to circle everybody at the same time because they're all powerful people. Just a huge responsibility that they have. Okay, next slide. So there's a website I like to bring your attention to. I like to say, oh yes, but that is the incorrect way of saying it just because I, see the letters and I say it. It's oh yay. And this is a free law project from Cornell's Legal Information Institute, or LII, Justicia, and the Chicago-Kent College of Law. And it's a multimedia archive devoted to making the Supreme Court of the United States accessible to everyone. So it is there for us as a resource. And I'm going to go ahead and open up this resource because it's such an amazing website that has evolved over the past 10 years or so. And here's, you see their webpage. And what I like to do is take us to the cases. And when you click on that link, it'll take you to the current term. So we're in the 2021-2022 of the U.S. Supreme Court. And here's all the cases that are scheduled for them. It's sorted by name, so alphabetical. Now, if we kind of just go through this, we'll see that some of these cases have already been argued. So some were on the 5th, some were on the 12th. Some happened today, I believe. I have to double check. Maybe they're on recess today. And these are the cases that are being decided. So I'll just go ahead and highlight 2 of them. The first one's Wooden versus United States, and this is a case in which the court will decide whether, under the Armed Career Criminal Act, offenses that were committed as part of a single crime spree but sequentially in time were committed on occasions different from one another for the purposes of enhancement. So the Supreme Court has to decide that question. Another case that is pending before the court that was heard is Mississippi versus Tennessee. So 2 states suing each other. A case in which the court will resolve a dispute over groundwater rights between the state of Mississippi and the state of Tennessee. So that was argued on October 4th. So here's a whole range of cases, and my hope is to choose 2 of these to then focus in on more detail over the next from weeks 3, 4, and 5, and then 6, 7, 8. So that's OYE website. And obviously you can go through all the terms back up until some time, until the beginning. So it's a really wonderful resource for folks who are interested in learning more about the Supreme Court. So the first concept I want to bring your attention to is the docket. And the docket is information about cases, both pending and decided, that have been filed at the court. The docket provides complete information regarding the status of filings beginning to their 2001 term. So if you go to supremecourt.gov, you'd be able to search their docket up for the past 20 years. And what's really powerful is that you get all the information, like who the petitioners, who the respondents are, but you also get the questions presented. And you might be asking, okay, what's that? Well, the questions presented in a granted or noted case can be obtained by first obtaining the docket report for that case, and then clicking on blue questions presented hyperlink located on the left-hand side. And then you can get a PDF of that file. So let's go ahead and take a look at the docket search on the Supreme Court's website. And I'm going to just pull one up for, see if civil liberties, the search term I had earlier. So there's a couple of cases here. I'll just pull up the first one. This is docket number 20-1499. This is the Civil Liberties Union versus the United States. This was docketed back in April of this year. And its decision date was November 19th. And it gives you whole list of what was going on here, a lot of documents, and so on and so forth. Let's see if this was actually heard, which might not be the case. See if pull up another case. Docket number 20-303. And here it's the United States versus Jose Luis Vallejo Madero. And this was back in last year. So let's click on the questions presented for this case. And here the question is whether Congress violated the equal protection component of the Due Process Clause of the Fifth Amendment by establishing supplemental security income, a program that provides benefits to needy, aged, blind, and disabled veterans in the 50 states and District of Columbia and in the Northern Marianas pursuant to negotiated covenant, but not extending it to Puerto Rico. So Congress said, we're going to establish supplemental Social Security income, but we're not going to extend it to the people of Puerto Rico. And this is a question of was a person's rights violated by the Congress when they passed this law, according to the Constitution. So just one of many examples of cases where you can search the docket. Next, we have cases. So the court makes available many different forms of information about cases. The most common way to find information about the course is to review the case's docket, a list of all of the filings and rulings in the case arranged in chronological order. The docket also includes links to electronic images of most filings submitted to the court after November of 2017. And you can obviously go and search through the docket, and in this case, OYEs. I'll just go ahead and show you an example here using the one we have of United States versus Jose Luis Vallejo Madero. And here is in time ordering what was going on. So September 4th, petition for writ of certiorari was filed. And you might be asking, what's a writ of certiorari? It's basically someone asking the court to consider hearing this case, because the court has discretion on deciding which cases it will hear to decide the question of constitutionality of either the Constitution itself or federal law or state constitution or state law or even local level things. So this was the request made to the Supreme Court. And there you can see like what else, other documents, brief amicus curiae for some folks. Who else was filing these amicus curiae briefs, or friend of the courts, which we'll talk about in a few minutes, when the information was distributed, when the petition was granted, in this case, March 1st, and all the way up until the end. Full documentation of what was going on. Obviously, there's a little bit of lag time between when this happens and when it's made public, but for the most part, it's pretty public, right? There's nothing that isn't available to the general going public who wants to read about a case and all its goings on. So that's cases. Next, you have amicus curiae briefs. So this is Latin for friend of the court. And frequently a person or a group who's not a party to the action, so someone who is not a petitioner or respondent, but has an interest in the matter, will petition the court for permission to submit a brief in the action with the intent of influencing the court's decision. Such briefs are called amicus briefs. Now, you might be asking, what's an example of an amicus brief? So let's staying with this case of the U.S. versus Vallejo Madero. Let's go and take a look here of a amicus curiae brief. And we'll see one here from the Commonwealth of Puerto Rico. So we'll go ahead and click on the main document. So this is a brief of the Commonwealth of Puerto Rico as amicus curiae brief in support of the respondent. So they restate the question. And then here's the table of contents, table of authorities, interest of the amicus curiae, summary of the argument, and then the argument. So in this case, the Commonwealth of Puerto Rico saying, first, the classification established by Congress excluding Puerto Rico residents from the SSI or Supplemental Social Security program is in reality based on race and our national origin. Thus, the proper equal protection analysis is strict scrutiny and not rational basis scrutiny, which is a type of test that the Supreme Court's asked to apply when considering these types of cases. Their second argument is that the Court of Appeals, and I'll zoom in just a little bit, the Court of Appeals for the Fifth Circuit correctly determined that even under rational basis review, the exclusion of residents of Puerto Rico from the SSI program violated their right to equal protection under the Fifth Amendment. And then their last part of their argument is the opinions of this court in Califano versus Torres, Harris versus Rosario are not dispositive of this case. And then they'll go on to explain the authorities that they have, and then the interest that the Commonwealth of Puerto Rico has. And I'm gonna go ahead and have this played to us so you can hear it out. Hopefully it just works. We'll see right now.
1. Interest of the amicus curiae 1. The Commonwealth of Puerto Rico respectfully submits this brief as amicus curiae in support of respondent, and for affirmance of the judgment of the Court of Appeals for the First Circuit, hereinafter First Circuit. Puerto Rican United States citizens enjoy far lesser rights than other United States citizens merely because of Puerto Rico's status as an unincorporated territory. This inferiority is both unconstitutional and unacceptable. The public policy of the government of Puerto Rico is that Puerto Ricans attain the same rights as those enjoyed by their fellow United States citizens living in the states, and that United States citizens who move to Puerto Rico enjoy the same constitutional rights as those who reside in the states. On August 25, 2017, petitioner, United States of America, commenced an action against respondent, Jose Luis Vela Madero, a Social Security Administration, SSA, Title 16 Supplemental Security Income, SSI, disability beneficiary, to collect, inter alia, $28,081 in overpaid SSI benefits after he moved to Puerto Rico. Petitioner alleged that the SSI is a federal income supplement program funded by general tax revenues, not Social Security taxes, requiring the beneficiary to be a U.S. resident in order to benefit from it. 1. 2. Thus excluding Puerto Rico. Both the District Court and the First Circuit ruled that the exclusion of residents of Puerto Rico from the SSI program is contrary to the equal protection component of the Fifth Amendment and is thus unconstitutional. This case involves issues of great importance to United States citizens residing in Puerto Rico, who are subjected to unconstitutionally unequal and inferior treatment by being excluded from the SSI program for the sole reason of living in Puerto Rico.
And so there you have the top part of the argument, and then they go on to summarize their argument in more detail. And then those three that I pointed out that were in the table of contents are expanded upon here. And so this is the Commonwealth of Puerto Rico as an amicus curiae, or as a friend of the court, arguing to the court why it should rule in a particular way or answer the question in a particular way. And so that's what amicus curiae briefs are. It gives someone who has an interest but isn't in the case itself as a respondent or a petitioner to weigh in with their views and opinions on the matter. Next, we have oral arguments. So the court holds oral arguments in about 70 to 80 cases each year, and the arguments are an opportunity for the justices to ask questions directly of the attorneys representing the parties to the case, and for the attorneys to highlight arguments that they may view as particularly important. So arguments are generally scheduled on a specified Monday, Tuesday, and Wednesday mornings, beginning on the first Monday in October and continuing through the end of April. Typically, the court holds 2 arguments each day, beginning at 10 a.m., each lasting 1 hour, and then the days on which arguments are held are identified on the court's yearly calendar. And specific cases to be argued each day and the attorneys scheduled to argue them are identified on hearing lists for each session and on the day call for each argument session. Courtroom seating is available to the public on a first-come, first-served basis. So if you're ever spending time in Washington, D.C. during October through April, and you want to spend an hour, 2 hours, maybe a little longer wait, if you have to wait in line to sit in on a Supreme Court case, you can do that. You just got to make your way to the building. You take an Uber or something, and they'll drop you off right there at the steps of the Capitol. And you just walk right up and get in line and get a seat. I'm going to open up the Supreme Court's website where they have the oral arguments, and just pull up the visitors guide, because folks are always asking, like, so how does this work? What goes on? So it tells you who the participants in the courtroom are. Obviously, the justices, the clerk, the marshal's aides, and the attorneys. Bar member seating. So attorneys who are administered to practice before the Supreme Court have a space. Others, obviously, law clerks, special guests, and news media. And then the courtroom seating. So I'm going to go ahead and just have this played for us so that we know just a little bit of background about that process, which is pretty cool.
All oral arguments are open to the public, but seating is limited and on a first-come, first-seated basis. Before a session begins, 2 lines form on the plaza in front of the building. One is for those who wish to attend an entire argument, and the other, a 3-minute line, is for those who wish to observe the court in session only briefly. Please do not hold a space in either line for others who have not yet arrived. Seating for the first argument begins at 9:30 a.m., and seating for the 3-minute line begins at 10 a.m. The locations for these lines are marked with signs, and there is a police officer on duty to answer your questions. Visitors should be aware that cases may attract large crowds, with lines forming before the building opens. Obviously, there are unavoidable delays associated with processing and seating large numbers of visitors, and your cooperation and patience are appreciated. Court police officers will make every effort to inform you as soon as possible whether you can expect to secure a seat in the courtroom. Groups with reserved seats should line up to the right of the 3-minute line.
So it goes on to just explain that process, and it's pretty cool, right? Just to know how things are and how they work, and where people are seated and what's happening and what's going on. So it's not a complete surprise to you as you make the effort to listen on a case. So that's oral arguments. And what we'll do in the following 3 weeks is listen to one, and then the 3 weeks subsequent, we'll listen to another set of oral arguments. So we can get like into the nitty gritty of what's happening at the Supreme Court. So I'm pretty excited to share that experience with you in the coming weeks. The last object I like to bring your attention are the opinions, right? So the term opinions are used here, refers to several types of writing by the justices. So most well-known are the opinions of the court announced in cases in which the court has heard an oral argument. Each sets out the court's judgment and its reasoning. The justice who authors the majority or principal opinion summarizes the opinion from the bench during a regularly scheduled session of the court. Shortly thereafter, a copy of the opinion is posted on its website. And so when you think of opinions, there's opinions of the majority and there's opinions of the minority or dissenting opinions. You can also have opinions that concur with the majority, but disagree on some element of the reasoning, or you can have opinions that concur with the dissenting opinion, but again, differ on the reasoning behind it. And so it can get pretty varied amongst the justices, but in almost every instance, unless there's a split court where it's evenly divided, which happens very seldomly, but it had happened in the final years of the Obama administration, the court will have a majority opinion and a minority/dissenting opinion. So these are the things that then decide the answer, what's the court's answer to the question before it. And then that's what serves as the basis for how the rest of the court systems going forward, both the district level courts, as we talked about last week, and the circuit level courts, which are on a regional level, will then decide cases that are very similar, if not like the case that was heard before the Supreme Court. So basically it creates a federal standard, a national standard for the question being asked. So with that, I hope this helps in getting you a sense of the Supreme Court and in achieving our learning objectives. So I'll go ahead and stop the recording and we'll take some questions and we'll call it a night. So thanks for taking the time. Take care.